and Licensing Committee requests the owner of the Riverside, Sam Naomi, appear before them and provide a coherent plan to address the nuisance property located at 3700 Northwestern Avenue. The recommendation of the Public Safety and Licensing Committee on 2/14 was to affirm their recommendation of Chief Howell that the property located at 3700 Northwestern Avenue be considered a chronic nuisance property. Excuse me. Also, recommendation of the Public Safety and Licensing Committee that the 3 forfeitures under section 66-1002 be enforced against the property, but only to start after the date on which the Common Council approves the recommendation that the property is a chronic nuisance property. And our city attorney has something to say on this item first.
So there has been some confusion with regards to the ordinance being valid, given the possibility of a sunset provision in the ordinance. So back in June of 2012, the Common Council did pass an ordinance number 2-12. That ordinance essentially repealed and recreated sections 66-101 and 66-102 of the ordinance. It also created section 66-104. At that time, the committee, it looks like the committee and the Common Council passed a sunset provision, meaning that the ordinance would only go into effect for a period of 3 years, after which time it ceases to exist. It was done in such a way that the sunset provision was not included in the body of the ordinance, so it was not published on the website. So we didn't know that it was part of the ordinance until we went back and looked at the legislative history. So it looks like it is valid nonetheless, even though it was not printed with the ordinance. It also was never officially repealed, which it probably should have been after the 3-year period expired in 2015. So that's why we didn't know that the sunset provision was valid. Nonetheless, it is valid. That means that in 2000, as of 2015, that ordinance, as it exists on the books right now, ceases to exist. So at this point, it would revert back to the version of the ordinance that was on the books prior to 2012. And that version would have been passed in 2003 under to the 2003 version of the nuisance ordinance. There is a procedure for the chief of police to declare a chronic nuisance. There is a procedure for the chief to cite for public nuisance premises. However, all of that is done without the involvement of the committee and without the involvement of the council. So at this point, the chief has been notified that he has that option to do that under the 2003 version and pursue it that way, but it would be without the involvement of this committee. So since the ordinance was enacted under what is essentially a null and void ordinance, I would ask the committee to receive and file this request as this procedure would be void at this time as well.
Well, I've got to say that I never understood the ordinance that says that the council had to affirm the chief of police declaration of the property of the nuisance. I was more familiar with the 2003 ordinance, which gave the police chief the full nuisance. So I was a little confused as to why this came before this committee or before the council, because we don't have to give our blessing to the police chief to do what he in his statute and ordinance is supposed to do. So I don't have a problem receiving and filing this. What I do have a problem with is a property that is a nuisance and that has continued to operate as a nuisance. And the police chief isn't here to tell us what his intentions are, but it would be my hope that with or without the council's affirmation, that he would declare the property nuisance and charge for the resources that the city has to continuously invest in that property because of it being a nuisance.
Gentleman in the back had his hand up.
I'm counsel for the property owner, and my name is John Knudsen. And I have a number of comments that refute what was presented by the city attorney, and additional information that the committee should have, I believe, in order, before you make the decision to merely take the report and file it. And the property owner was directed to appear, and failure to appear might result in forfeitures. So he was directed, sent a certified mail on the 23rd of February, which was received February 27th, yesterday, that told him to appear. That was the first notice he had of this meeting where they wanted him to appear.
Well, at this point, this is going to be received and filed. I don't know where it's going to go after this.
I'd like to see the notice that
Okay.
the property owner provide. Can I see the notice, please?
All right. I believe the committee should receive the comments that I have on behalf of my client, because I disagree with the legal opinion that you've received. And I have some updated information about the quote nuisance that I think the committee should be aware of.
So you're saying it's not a nuisance property?
I'm saying that, number one, the ordinance, the 2003 ordinance is invalid. That the owner presented a plan. Ironically, we received from the police department today a list of the quote, calls that have come to the property in January and February, and they total 8.
Well, whether it's a nuisance property, that's the chief's discretion on that. We have nothing to do.
Well, that's what I wanted to speak to, because I don't think the chief has the discretion. And that it'll take me 5 minutes max, and I have copies of the ordinance and copies of the letter that was presented to the board, which caused it to be sent back to committee, and also other information that I think will be helpful to the committee.
The committee is receiving and filing the action today. Can certainly do that if Mr. Knudsen would like to speak with the chief or with the city attorney's office regarding whether or not we should pursue any other action at this point. You can certainly contact us, but I don't know if the committee needs to hear all of this right now, if it's just receiving and filing and not taking any further action at this point.
Well, that would be my understanding as well, that we don't know what the chief is going to do, and we have no authority over that. So if the chief does determine that this would be declared a nuisance property, that would be something that you, Mr. Knudsen, would take up with the police chief and the city attorney's office. There's really nothing that we can do, because
The only point I would make is that you're proceeding under the assumption that the 2003 statute is valid, and it isn't. It was repealed by the 2012 ordinance. And so you wouldn't go back to the chief, and my recommendation, there's an old saying in the law that free advice is always worth what you pay for it. My advice to this committee is that if you want to have a nuisance ordinance, that you decide what it is you want, and then you go ahead and go through the normal procedure and pass an ordinance. Because in our legal opinion, right now, there's no nuisance ordinance in the city of Racine.
Well, respectfully, Mr. Knudsen, the committee does have legal counsel at this point, and they do have advice from the city attorney's office. And if you wish to argue the legality of that ordinance, I suggest that you contact our office.
Well, or else we'll contact the circuit court. And that's what I'm trying to avoid, but I'm not getting any cooperation. So if you don't want to see the materials we put together, if you don't want to see a copy of the exact original ordinance signed by the clerk and the mayor that says that it was sunset and says that the previous ordinance was repealed, then that's fine, we can deal with it, but I don't think it's doing the city any benefit to not hear it.
Attorney Knudsen, on this, all we're gonna do is receive and file it. It'll come back to us when you deal with them, because the attorneys are the ones that are the legal beagles for us. We don't have the knowledge you have and what they have. And I think you're missing the boat. We're not out to hang him or do anything to him.
Oh, yeah,
We're
you are.
just out to receive and file this issue and work it out with the attorney. It'll come back to us eventually. And then you may be very right on what you're telling us, and I don't have a problem with that. But it's something that this committee has no power to do right now.
Okay. We will, we'll take the appropriate action. We will contact the city attorney again,
Well, I hope you do.
but we may end up in court, and I was hoping to avoid.
Yeah. We agree with you on that, yeah.
Okay. Thank you. Okay, we're all- Oh, I'm sorry.
No problem.
We already did that. Sure.
Oh, go ahead. This is the good stuff.
You made that motion? I'll second it.
All those in favor?